Is anyone talking?
This is
Sorry, I
Ryan.
was.
Oh, have announcements, please.
This is Stephen Weller on behalf of El Paso Water.
And this is Ryan Green on behalf of the plaintiff Paseo del Este.
Okay, and we have this morning the defendant's motion for clarification, modification of the summary judgment order and to sever claims. I think there was also a supplement filed yesterday. I thought I had that one as well. A supplement filed yesterday. Mr. Green, did you have an opportunity to review those?
I did have an opportunity to review them. I think it's pretty straightforward, so we did not file a response in advance. We're opposed to the relief requested, the primary reason being that there's really not a dispute, that there's no final judgment yet, and so there's no need for any action by the court. The plaintiff has a claim for attorney's fees that has not been adjudicated yet, and so what we were going to do is file a motion for attorney's fees in conjunction with a motion for entry of final judgment based on what the court has already ruled on summary judgment. And so there's no need for any modification to say it's a final judgment because it's not a final judgment, basically.
Mr. Weller, let me hear from you, please.
Your Honor, we're in agreement that it's not a final judgment, and I'm glad that we've got that on the record. Let me give the court a little bit of background on this. There may be some housekeeping necessary. I mean, if PDE wants to ask for attorney's fees, then they can do so. They haven't done that to this point in a motion, and they haven't pled for that in a way that would allow them to get attorney's fees. And in addition to the fact that EP Water is immune from a damage claim of that type, so there are problems with a request for attorney's fees. But separate and apart from that, the reason for our motion is that the order that was presented by PDE that was signed on March the 12th is really a partial order. It's an interlocutory order on partial summary judgment that only addresses the deck action claims asserted by PDE on the two disputed charges. The order does not overtly mention the utilities claims back against PDE. We assume that the court didn't intend to grant those, but if for us to have a final judgment, we need to dispose of all claims and forms of relief. So we were asking that the order state what the court's determination is on that. And then separate and apart from that, the utility has asserted two unrelated claims that are different than the two disputed charges, Your Honor. And, it's understandable, the meat and potatoes of this case relates to those two disputed charges, but there are two other claims that were made back and forth, and they haven't been adjudicated. One of those is that at one point, PDE was claiming that they weren't responsible for paying a third charge that was discussed in that Exhibit J, which was a conservation credit. Since then, PDE's expert reversed his conclusions and said, no, we should be paying that. We should have been paying that from the beginning. And then on top of that, this lawsuit's been pending since 2021, and PDE was not paying the rate increases, the standard rate increases unrelated to the disputed charges. So they were paying a rate frozen in 2021, and they weren't paying the updated rates. So we brought this issue to their attention last year when we figured it out. It took a few months. PDE made a payment towards those that unpaid balance, which had grown to about $500,000 at that point, Your Honor. And so we thought that this issue might have been resolved, but I learned yesterday that the payments since the PD made its payments in January of this year to cover periods through December of 23. They're continuing the same problem. They haven't corrected the issue in the most three recent payments. So we have an ongoing issue with short payments. Those two claims, the conservation needs or the conservation charge and these other unrelated payments are different than the other claims in this case. They don't have any clear, factual dependency on the other claims that have been made. We don't know sitting here today how those are going to be resolved or when. But it is the utility's intent, respectfully, and we respect the court's rulings, but it's our intent to appeal PDE's summary judgment. In order for us to do that, we want to do some house cleaning. We'd like to take these claims, sever them, put them off in another cause number. That's not going to cause prejudice to anybody. If PDE is going to pay them, great. If they're not going to pay them, then we may have to go move for relief from the court on that. But we're requesting that they be severed and set off to the side, and then we can deal with any motion to create a final judgment on the two disputed charges. So that's my request there. Additionally, Your Honor, this is maybe just a matter of housekeeping, and I know everybody's agreeing on the record that we don't have a final judgment, and I appreciate all the candor on that. But we did get a Rule 306A notice, Your Honor, which is a notice when you get a final judgment. And so, again, very understandable that there may have been a belief that would have been a final judgment given all the focus in the last summary judgment hearing, but we don't have a final judgment. And so, the 30th day from the date of the court's order is tomorrow. So we don't want there to be any ambiguity about the timing of the notice of appeal. We would request that the court take a couple of housekeeping steps while we sort this out. One, to rescind the 306A notice, please. And two, to vacate the order that exists now. I'm not asking the court to change its rulings on that, but to vacate that order so that it's not there and we don't have any confusion.
Your Honor, may I respond?
Were you done, Mr. Weller, on that so far?
Yes, Your Honor. Thank you.
Okay, Mr. Green, go ahead.
Yeah, so there's only two disputed issues, and that's what the court ruled on in summary judgment. Any other issues with payment, there's no disputes there. As soon as they told us that we were under withholding more than those two disputed issues would cause to be the case, we went in, we did the calculations, and we paid him. And you just heard him say it was over $500,000. We paid him over $600,000 early this year. If there continues, and as Mr. Weller just said, if there's still an issue with our payments, he says he just found out about this yesterday. Well, then we just found out about it, and we'll fix that. So that's not an issue the court needs to get involved in. And what our goal will be is by the time we get our motion for attorney's fees on file, and we do plead for attorney's fees, that is a live issue. They may think that this court doesn't have jurisdiction. They may think there's substantive flaws, but it's still a pending claim. And as long as there's that pending claim, we don't have a final judgment. Not all claims have been resolved. So what our plan is to file a motion for attorney's fees as well as for entry of final judgment. And in conjunction with that, to make sure that both parties are on the same page, any amounts that my client owes that are not related to those two disputed charges, we'll have resolved that. We'll have paid any amounts we owe. I don't think we owe anything, but we're in discussions about that. I called Mr. Weller earlier this week and said, hey, I didn't realize there were still disputes. As far as what we've paid or haven't paid, give me the numbers. So this is not anything that needs to be severed out. In fact, it would actually be error to sever it out because all of these claims talk about how much we owe each month, whether it's the two big disputed issues or any other aspects. So there's no point in severing out an entirely different lawsuit over additional features of those monthly bills. So there's no need for the court to act at this time to sever. And in fact, I don't think it would be appropriate to do a severance since all of this is just talking about the monthly amounts that my client pays to El Paso Water. As far as rescinding any sort of 306 notice, 306 notices don't establish appellate jurisdiction. It's the order itself. The Court of Appeals never looks at a 306 notice. The Court of Appeals just looks at the terms of the order and figures out, is this a final judgment? It's clearly not. There's no Mother Hubbard language. There's no language saying this resolves all claims. There's no language resolving our claim for attorney's fees. None of that. So there's no actual issue looking at the record on whether the court's order on the summary judgment was final. It's not. It did resolve, like counsel just said, the quote unquote meat and potatoes. It resolved what's actually in dispute. And so we believe when Your Honor sees our motion for attorney's fees and motion for entry of final judgment, it will be clear that there are no disputed issues left on the amounts we owe or don't owe El Paso Water. The only question is, are there also attorney's fees? And the court's ruling on summary judgment will resolve all the parties' different claims. We can make all that clear. We absolutely oppose the vacating of the court's order. The court's order was what the court ordered. There's no need to vacate it. At most, if the court wants to put something in the record indicating that that order is not final and appealable, that's fine. But to actually vacate the order that the court entered after very long hearings and a lot of deliberation, we're absolutely opposed to that. And so if Your Honor has any questions on that, but there's just no need at this juncture for the court to do anything because both parties are in agreement. We don't have a final judgment yet that's appealable, but we're going to get there. We just need to do the housekeeping that requires to get from this summary judgment order to a final judgment.
Mr. Weller?
I'll just respond briefly. So we disagree on the severance. I don't see how it's going to hurt anything or cause any sort of issue to sever those claims. I know that PDE's position is they're going to take care of it, but they have not to this point, and it's looking like an ongoing issue. We have a rate update in April of this year. We don't know whether they're going to pay those rate updates. So they have been withholding funds related to those rate updates. They made a payment towards it, but the root problem still exists. The utility may decide that they want to move for summary judgment on that to have finality and a court's order on that point. And PD is like, we don't want to sever it. We want to just take care of it. It's like, well, we have a right to pursue those claims. They're unrelated. And it's common, when you have an interlocutory summary judgment, for those summary judgments to be severed off so that the parties can appeal them and pursue their rights in a timely way. And we would like to, split these cases up, because they're unrelated issues. They can be adjudicated separately. So that is one of the pieces of the housekeeping, is to sever those claims. And we've established under Rule 41 the grounds for severance. PD has not responded to that in writing. They were supposed to have. They've not responded in writing. So we think the severance is appropriate, and then we can go forward and address the finality of the other claims pending before the court. One thing, the Rule 306A notice does not establish jurisdiction of the Court of Appeals, but it is an indication of the court's intent. Or an intent, some evidence that it might be a final judgment, and we would just like it to be rescinded, or it to have something in writing from the court indicating that this is not a final judgment.
So with respect to that, the 306 notice, Mr. Weller, I'm absolutely happy to have the court memorialize in an order that it's issued by the district clerk's office. So I'm absolutely fine however you want to word it. In other words, rescinding, I don't know how I rescind something that comes from the clerk, but just an order indicating that the order on the motion for summary judgment was not final. Whatever language you're comfortable with, please send it in a proposed order. I'm comfortable with that. In terms of vacating the order on the motion itself, I don't have it in front of me, but I feel like I remember it. I hear what you're saying, Mr. Weller, but I don't think I have to vacate that order.
Yeah, I understand.
Mhm.
I think we're all saying the same thing, just trying to get to that, trying to get to the clarification. That's all.
What I would like, a little more, I'm happy to hear your response, Mr. Green. Now, I would love a response on the severance, the request to sever those claims. If you're prepared to respond today, I mean, the motion for severance was part of the initial motion for clarification. So, you know, it's been about 3 weeks or so. What is the position of PDE on that? I mean, I've heard you say could be error to do that, but it seems just in terms of organizing what's left, it makes a little bit of sense.
And I think we are opposed to it, and one of the reasons is it won't actually accomplish anything. The whole purpose for a severance in this sort of situation is to get to finality on one part of the case, and severing out the hey, you still owe us money piece doesn't cause the main piece to get to finality because we still have our fee claim. So there's no actual efficiency created by it. The most efficient outcome would be keep them together, and we'll make sure by our motion practice we resolve everything at once. We're not going to do a motion for fees with the other issues still out there. We will resolve it, and this part is really important on that, because Mr. Weller just said we're withholding payments still today. He literally first informed me of this issue at 10:37 a.m. this morning. So this is not some sort of situation where we're intentionally withholding payments that need to be owed. I don't know why we're arguing about that in front of the court right now when we've, as I said, paid over $600,000 the last time they told us that amounts were still owed. So this is not an issue where we need to sever off this question on a part of a case that eventually would just be resolved by the parties anyway, because we're not actually disputing what that we owe amounts other than those two dispute points. So that's the first point. As far as efficiency, there's no actual reason this doesn't add any efficiency to the process to sever it. As far as the substantive, my comment that it would actually be error. So you can sever when the issues are not intertwined, when they're completely separate sort of issues. But that's not entirely the case here because, as I said, we get one monthly bill. And the fight is over how much of that monthly bill is correct. And this court has already ruled on the two big issues that there are two aspects of the monthly bill that's incorrect, the 10% surcharge and the peaking calculation. So to then sever out a dispute of maybe there's a third issue that's incorrect with these exact same monthly invoices, it doesn't make sense to me to sever in that. Now, if Your Honor wanted to do that, I mean, I don't exactly know how much harm there would be in that because we would have this separate severed standalone suit that would just be resolved and ended up dismissed because we're going to pay whatever we owe. But that doesn't advance the ball in the main case in any way. And so that's the concern I have is that we're going to, if Your Honor severs it and we find out there actually is an overlapping issue hiding behind the scenes on their claiming that there's an undisputed amount owed, but then we do the calculation, it turns out that's part of the disputed amount. So it creates real potential for confusion. And so if Your Honor's at all considering granting the motion to sever, then I would at the least say hold off on that and see if the parties can resolve the issue that they want severed in the first place.
Okay. Anything else, Mr. Weller?
Your Honor, I think I've stated our points. I mean, they're unrelated charges. They're distinct from each other. That's why they can be separately calculated. And we are trying to get to the ultimate purpose, which is to clear this up, do the housekeeping, but dealing with these claims is part of that.
So, do you all have anything else?
No, Your Honor.
So the motion for clarification and modification, that is respectfully denied. The motion to sever claims, the court is going to take under advisement. I understand, I'm not seeing anything, but I understand there are matters forthcoming. I see we still have on the docket, our docket call, which is not a docket call. I don't believe I actually want to set this for a final. I guess we can do a final status conference on that date, but I'm anticipating that being the time where I will readdress the motion for severance, and I will see some other pleadings in line with what you all have discussed today. If that timetable doesn't work for you all, for example, Mr. Weller, some of these things you mentioned, were, I guess, brought to everyone's attention as late as yesterday. I know the supplement was filed yesterday. I absolutely will work with you on that. But I would like to try and use that date. If not, like I said, I will work with you all, even if it's sooner.
Wait, I'm sorry, Your Honor, I missed the part. You said which date was that?
No, we still have our scheduled docket call and jury trial. So that docket call on May 8th at 10 a.m. I am going to convert that into something like a final status conference, but I would love to use that time to hear anything that you all want to present to the court that we've discussed today. Okay.
Your Honor, and one last thing I just want to make this clear is that we learned yesterday that the payments still weren't in the correct amounts. But this was something that PDE was notified about last November. And that it's clear that they've known that they were short paying. So it was addressed, but they didn't stop the short payment. So PDE knows better than I do that they're not fully paying their bills. And what we're identifying to them is, hey guys, you're still not fully paying. That may not have been known to Mr. Green until this morning, but it was known to his client. So,
well, anything in those lines, I am absolutely willing to have said if you all file things on that date. And again, we can use that date. It's, it's within 30 days. So if you all stay on top of it and want to do that, if it gets more complicated, like I said, we can find another time that works better for both of you. But let's shoot for that. So for now, we're going to change those settings. Obviously, the 9th and 10th are canceled. May 8th, I'm going to convert that to a final civil pretrial, anticipating, and I hate to be so flexible because then it means that things get out of control. But I'm really saying to you all, anything you filed in the next 2 weeks, we're going to set on that date to be heard. After that, then it gets a little trickier because I don't really want to see anything on, I don't want you all to get all excited on Cinco de Mayo and decide you want to file something and have it heard on the 8th. That's not going to happen. But if we can get things filed, say in the next 2 weeks, then you have your hearing date. Okay.
Yeah, that all makes sense, Your Honor, and I think that absolutely works. We'll get something on file that can be heard on May 8th and see if we can get to finality on this.
Mr. Weller, if you will also get me that order, I did see that when I looked up the supplement yesterday, those notices. I hadn't gone back to the Odyssey. So please, if you'll get me an order or something, some proposed language on that, and I'll get that filed today.
proposed language that would
Indicate
that
that-
regardless, yeah, I guess it would rescind. I don't know if the court can rescind something issued by the clerk's office.
I agree, which is why you had made the suggestion of just filing something that indicates that the summary judgment was not a final judgment. And let me go back to the notice. Was
Yeah.
order signed by the president in the above style, a copy of the judgment, and please note there is a fee. send me something with some language, and if I feel I need to tweak it, I will. Please. Okay. All right. Anything else?
Not from plaintiff.
Okay. Also, like I said, if you need something sooner than the 8th, let me know. Send the pleading, request a hearing, and we'll get you scheduled. Okay.
Thank you.
Thank you.
Very much for your time, gentlemen. Have a good day.
You as well, Your Honor.
Miss Ariana Ortiz and Miss McLaughlin. Good morning.
Good morning, Judge.
Let me go back. Okay, this is 2023 DCV 2147 Magdalena Kabatic et al.
Kabatik.
Versus Kabatik. Versus Julia Macias. May I have announcements, please?
Ariana Ortiz on behalf of Magdalena Sabatic.
Christina McLaughlin on behalf of the defendant.
And scheduling status conference. Ladies, are you all ready for a trial setting on this case?
Yeah.
Go ahead.
Oh no, Ms. Ortiz, go ahead.
Oh, I was just going to say, we do have a proposed mediation date of June 27th right now. We're just trying to confirm that everyone can make it. I believe, Ms. McLaughlin, we're good on June 27th.
I believe you've been scheduling with my assistant, so I don't have that email in front of me, but if she's confirming it, then yes.
Okay.
So I'm going to ask the question that I really don't want to ask because that'll put us out like 3 months, right? Do y'all want a trial date now, or do you want to come back for a status after your mediation?
I think a status would be good, Your Honor. I think it's a case we can get settled.
Okay,
I agree, Judge.
so we'll look at, actually, we're gonna, you said it was June 27th, right? So that's gonna put us out of pocket a little bit. I'm gonna have to put you back to like July 17th. If we get a notice from you all, great. If not, just know that if it's not resolved, I'm probably gonna put you on like a 9-month trial track rather than something a full year out, okay?
Understand. Thank you, Judge.
Thanks so
Your
much.
Honor.
Good luck.
Thank
Have a
you.
good day. Thank you. Bye-bye.
Excused.
Yes, ma'am.
Thank you.
Thank you, Miss
Ms.
Bertha.
McLaughlin.